This is one of the biggest acquittals for narcotics crime in Ghana's legal history. The Republic versus KWABENA AMANING, alias Tagor and Abbas. It began with a rumor that a vessel, the NV Benjamin, was carrying cocaine heading towards Ghana's shores. But what made this rumor extraordinary was what came next. That some men had paddled out in a canoe and stolen 76 out of 77 parcels of cocaine from the vessel while it was still at sea. The claim gripped the nation. Media houses ran wild with it. Public anger surged, and soon the government responded by setting up a high-level committee to investigate. It was called the Georgina Wood Committee, chaired by none other than the Chief Justice herself, the Honorable Lady Chief Justice Georgina Theodora Wood. But after all the testimonies, interrogations, investigations, media spectacles and whatnot, the committee came up with nothing. They found no trace of the alleged 76 stolen parcels of cocaine, assuming of course that they even existed. Then the case took a dramatic turn. Two names entered the frame, Tagor and Abbas. They were secretly recorded having a meeting with ACP Kofi Boakye, then the Director of Operations of the Ghana Police Service. Now, according to the facts narrated by the court, ACP Boakye's name was being linked to the stolen cocaine, and it was Abbas who was reportedly behind those rumors. So the officer invited both Tagor and Abbas to his house. He had two objectives. First, to clear his name, and second, to find out who actually imported the drugs. The court noted that ACP Boakye was within his rights to act in that manner, and even stated that as a senior police officer, he was entitled to employ both lawful and even at times unlawful means to find the perpetrators of the alleged crime. But the meeting itself, it was not tense or investigative. It was light. The men joked, bragged, talked wealth, connections, and power. Amid these discussions, Tagor claimed that he had credited about 100 kilograms of cocaine and arranged for its payments in Holland. Abbas responded, saying that he too had been involved in cocaine dealings with Tagor, but claimed he was cheated. Tagor denied this. On the issue of the 76 missing parcels, one of them remarked, "Nipa bako into Mindi," to wit, one person cannot enjoy all the benefits. These offhand comments, this careless conversation, became the foundation of a criminal case. The public was hungry for justice and the state acted. Tagor and Abbas were arrested and charged with 3 offenses. First, that they had conspired to cooperate to find the 76 missing parcels of cocaine. Second, that Abbas had admitted to promoting a cocaine enterprise wherein Tagor had cheated him. Third, that Tagor had admitted to crediting about 100 kilograms of cocaine and arranging for its payment in Holland. It looked straightforward. 2 men caught on tape, statements that sounded like admissions. The prosecution brought 11 witnesses, including Professor Openi Ajekum, and other witness who described himself as an expert in the drug underworld. The trial was presided over by Justice Jones Doche, and at its conclusion, both men were convicted and sentenced to 15 years in prison with hard labor. But now here is where it gets interesting. The case went to the Court of Appeal, and there the real test began. The courts laid down the immovable principle of criminal law that the prosecution is obliged under law to establish the guilt of the accused beyond reasonable doubt. And this burden does not shift, does not change according to the charge preferred, the public concern, or the status of the accused or the complainant. And then came the judicial reckoning. At the close of the prosecution's case, the court found that no wrongdoing had been established against the accused persons. It stated that the trial court erred by asking the accused to open their defense, because the threshold to call an accused person to answer a charge is not let's hear from you, it's beyond reasonable doubt, and that standard had simply not been met. The court broke it down simply. First, all 11 witnesses failed to establish that the accused had committed any crime. Second, on count 3, the only evidence was that Tagor said in ACP Boakye's house that he had credited 100 kilograms of cocaine and arranged payments in Holland. On count 2, the only evidence was that Abbas said during the same conversation that he had done cocaine business with Tagor and was cheated. There was nothing else. No cocaine, no transaction records, no locations, no proof. Only what they allegedly said in a casual chat. Then the court did something remarkable. To show how absurd the conviction was, it created a hypothetical courtroom exchange, asking the question, what activity did Tagor undertake with the purpose of establishing or promoting a narcotics enterprise? Answer by the prosecution. Well, he said in the house of ACP Kofi Boache that he credited 100 kilograms of cocaine and arranged for its payment in Holland. Question: when exactly did he say this? Did he indicate? Where did he say he credited the cocaine? I don't know. Who was supposed to pay for the cocaine in Holland? He didn't tell. Imagine sentencing a man to 15 years in hard labor based on that. No date, no context, no corroboration. Just a casual boast captured on tape. And that became the basis of the conviction. The Court of Appeal, speaking through Apal J.A., as he then was very firm that this is the first time in my entire career that I have seen a conviction based on a mere allegation by a rabble-rouser or a braggart that he had done something criminal in nature, when there was no evidence suggesting that the alleged offense had even occurred. The court made it clear all the authorities cited by the prosecution did not apply, because in this case there was no corpus delicti, that is, no facts proving that a crime had actually been committed. They gave another example. If someone says he has killed a human being and there is no independent corroborative evidence to support that fact, that person cannot be dragged to court and convicted on the basis of what he said, when the corpus delicti, which is the facts proving that crime, had not been established. And in the case of Tagor and Abbas, there was no such independent evidence. No crime was established. The court rejected the claim that what the accused said on tape were confessions. They ruled that a true confession was an admission of guilt made before proper authority or to another person by either a suspect who was facing a criminal charge or someone under investigations. At all material times, confession assumes that a crime has occurred, but here the prosecution couldn't even prove that. And so came the damning final words of the Court of Appeal. The convictions and sentence of the appellants on all the charges constitute a cancerous tumor in our legal anatomy that should not be made to eat into and infect our lower courts. You need to be flushed out from the system and confined to the waste bin. And that is what this case truly is, a cautionary tale that no matter the media storm, no matter the political pressure, in criminal law, allegations are not enough. A man's liberty cannot be taken away simply because of speculation. Only proof beyond reasonable doubt can justify a conviction. And where there is no proof, there must be no punishment.